Welcome to the Chapter 15 Top 12 Highlights. I'm Mr. Rodman. Are you living the five? Let's talk civil liberties. First of all, let's differentiate between civil rights and civil liberties. As we talked about in class, civil rights is equal protections for a group of people. This is based on race, gender, ethnicity, national origin, disability, a type of class of group of people that is protected under the equal protection of the 14th Amendment as well as due process of the law. Civil liberties is more about individual protections for freedoms that you would like to exercise, such as religion, speech, conscience, the press, assembly, right to bear arms. The individual freedoms and constitutional protections you have are the civil liberties, and that's what we're going to focus on this chapter in chapter 15. We'll come back to the civil rights in chapter 16. So in looking at this from that perspective, we have selective incorporation, the idea of applying the Bill of Rights to the states case by case, amendment by amendment. This is not designed to be a full-scale activist court that is basically blanketing the Bill of Rights saying it all applies to the states. No, 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 they're doing it amendment by amendment and case by case. Remember, they're looking at this according to cases, not according to what do they want to make an issue of. They're not about legislating policy. They're about focusing on cases that address issues that are pertinent, and that is really their focus. So that's why they're applying the Bill of Rights to the states on a case-by-case, amendment-by-amendment basis. The latest one to be incorporated was the Second Amendment, the right to bear arms, and we saw this in the 2008 case DC v. Heller. Notice the graphic here will show you all except the Second Amendment, but it basically takes you through the color code of each of the amendments that have been incorporated selectively, case by case, amendment by amendment, for various aspects of that amendment. So look at the First Amendment, for instance. You'll see freedom of speech incorporated with Kelo, freedom of the press with Neer v. Minnesota, the free exercise of religion with Cantwell v. Connecticut, the NAACP versus Alabama in terms of freedom of association. All of these selectively incorporating the Bill of Rights to apply to the states on that case-by-case basis, looking at that amendment. So McDonald v. Chicago basically upheld the same principles as the state laws we saw in the DC v. Heller case, but that was in 2010, upholding the law that was basically decided and incorporated in the DC v. Heller case in 2008. Now let's look at the Establishment Clause versus the Free Exercise Clause. Notice the First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. There it is, that establishment of religion and prohibiting the free exercise thereof. That's where our two clauses that we're looking at here in the First Amendment come from, based on religion. So the Establishment Clause, liberal justices look at this as more as a wall of separation, a standard of state being on one side and church being on the other. Conservative justice is not quite seeing that same wall of separation. They look at it in terms of government can aid a religion or religions along the way, as long as they're not establishing the preference of one religion over the other for the entire country, in terms of showing that preference as an establishment of that religion. So no better case to address this than Engel v. Vitale, looking at the students who were leading classmates in a short non-denominational prayer. The Supreme Court said this violates the Establishment Clause of the Constitution. It is unconstitutional. Now we look at the Free Exercise Clause, which basically said government can't compel people or force them or prohibit them from their free exercise of religion, any religion they want, including no religion at all. This goes back to the provision in Article 6 of the Constitution that's also in your reading guide, looking at the religious test provision. There cannot be a religious test in order to be able to run for office or in order to be able to apply for citizenship. This would violate Article 6 of the Constitution itself. So as long as it as long as there is no religious test, people can run for office. People can exercise freely, including not exercising any religion at all, because under the Free Exercise Clause you have that right. Now, notice that the law can prohibit conduct as long as it's not targeted at a certain religion if it involves free exercise that kind of tests the boundaries. And we talked about this case of the Employment Division of Oregon v. Smith in the peyote case. Using it as part of your religion on the job is not qualified as free exercise, and the court agreed. And polygamy also not under free exercise. It doesn't give you those rights under the Free Exercise Clause. So there are limits to that free exercise. Looking at some of the school cases, then, we have Tinker v. Des Moines, the symbolic speech is free speech case with Mary Beth Tinker and her brother basically wearing armbands to protest the Vietnam War. This was not a substantial disruption of the educational experience, and therefore it was symbolic speech. It was qualified under the First Amendment, and it was constitutional. So it's a very important case in that regard. Hazelwood v. Kuhlmeier, this idea of prior review. Do administrators have the right to censor your school newspaper or your yearbook if it's deemed to be offensive or of concern, or even if it's not? Now, in Montgomery County, we don't have prior review, but in many school districts across the country do. And I attended when I was a yearbook advisor at another school, I attended a summer workshop where I met a lot of yearbook advisors and newspaper advisors that actually did have prior review. They had to submit all of their pages to the principal or to an assistant principal for review prior to sending them to the printer or the publisher. Many schools have that. So in the case, the Supreme Court upheld the censorship of school newspapers, saying it's part of the curriculum. The administrators and school officials do sign on to what curriculum people are teaching. So as a result, they do have the right to censor that school newspaper. It is not the same freedom of speech that you see, or the freedom of the press that you see in the First Amendment that outside groups like the New York Times, the Washington Post, or the Wall Street Journal might have. So it is different for school publications and school media. Now, Lee v. Weisman basically said you can't invite a member of the clergy to give a prayer at graduation because that would be a violation of that idea of establishment clause. And the Westside Community case in 1990 basically said if you're going to allow groups to meet, you have to allow religious groups that are led by students to meet as well. So if you're going to allow secular groups or non-religious groups, you have to allow religious groups as well. And that was upholding that case. The courts have struck down school prayer. We talked about this in terms of creationism in public schools, ministers at graduation, as we just looked at in that case, and organized prayer at football games. All of those have been struck down by the court as unconstitutional. However, they have upheld the idea that students can pray on their own time. Maybe it's in between classes, or before a class, or at lunchtime, or before school, after school, as in their own way, and however they wish to do that, as long as it's outside of the educational time period in which you are in classes and in curricular instruction. The West Virginia case here looked at the idea of the Pledge of Allegiance. Jehovah's Witnesses claiming that it was against their religion in order to have to say that, and the Supreme Court agreed, saying students shouldn't be required to do that, not just for religious reasons, but for any. That also includes teachers, and really strikes at the heart of that religious separation model that we were talking about with the Establishment Clause, in terms of, can we prohibit them from their free exercise when they're not allowed to say the Pledge of Allegiance? And the Supreme Court upheld that, saying they agree it was a violation of their free exercise to do so. The Fifth Amendment looks at eminent domain, this idea of being paid just compensation for property that's being taken for the purposes of a public good. The question of what is a public good always comes up in terms of how a government can take the property. But in Kelo v. New London, Connecticut, this was a case in which the court actually ruled that the city of New London was within the rights to take the property, the Kelo's property, for private development, being turned into a public good. It was very controversial. At the time, it led lots of states to amend their constitutions to change their laws, basically saying that the right of private property is golden in terms of the rights of individuals and private citizens to own property, and the government can't take that away from you just because they want to develop the area into something that could benefit the city. So while it did, while the Supreme Court did rule for the city of New London, the project, by the way, never got off the ground. They did move the Kelo house to another property, and then the recession hit, and basically the place sits idle. You can Google it and see the property, but it's still sitting there, a grassy knoll. As it was back during the case. Number 6, the freedom of speech. We kind of talk about this a little bit in class. You can't say just anything you want to. Your speech is protected, but your speech ends where someone else begins, such as if you're making a threat or saying something about inciting a riot or some type of violence. That would not be the case. As I mentioned with Justice Ginsburg in her latest autobiography, saying you can swing your arm anywhere you want to, as long as it doesn't impugn someone else. But once your hand hits someone else's nose, then your rights end and that person's begins. So it's really important to keep that in mind. Libel, this idea of defamation of another person, they're putting it in writing. This is different from slander. It does have to be proven to be false, but in New York Times v. Sullivan, the idea here was that the newspaper had to know or have known, and it had to be proven that the statements were false in order to be able to prove it. And if the court said that if they can actually prove malice, then it is likely that they can make that case. Now, having said that, it's important to note that the court actually said that there's a really high standard here, and they are really serious about freedom of the press. So to go to basically sue a publication or a member of the media or a media organization, you really have a high standard to meet in terms of proving that there was actual malice, because so many times the courts will side with the freedom of the press here, and especially when it comes to public officials, political officials or elected officials, people that are running for office. If you're a politician and you're running for office, you're open season, and you really have no leg to stand on in terms of being able to sue a media organization and say that they are falsely accusing you and there was actual malice here. So the standard is very, very high. Now, let's look at this in terms of contemporary standards for obscenity. Basically, the court said, I know it when I see it. This is a contemporary community standard, which has changed over the years. I mean, go back to I Love Lucy, where Lucy and Ricky slept in separate beds because you didn't want to show that on television. Obviously, we're in a different era. The contemporary community standards have changed and evolved over time. But the idea here is that the obscenity laws within a town or within a community do change based on that contemporary community standard, also based on the SLAPS test, this serious literary, artistic, political, or scientific value that is given to it. It's not obscene if it can pass that SLAPS test, and obviously if it can't, then it would be labeled obscene, and the community can basically outlaw it or regulate it in some way, shape, or form. Fighting words, the hate speech, obviously yelling fire in a crowded theater, none of those are protected speech. Someone going on Facebook and saying I'm going to kill the president is not something that someone can do. You will get a visit by Secret Service or other government officials. Those are fighting words. Those are not protected speech under the First Amendment. Now, also, it's important to note that commercial speech, advertising, and this is again getting harder and harder to prove, but individuals can sue and laws can punish this if your statement is false or misleading. We've seen lots of advertising. There's the truth in advertising laws that have been passed. Again, it's really hard to prove, but if you can make a case for it. It's just again, it's an uphill climb in terms of trying to prove that. Now, then came along Morse v. Frederick in 2007, this bong hits for Jesus case that basically said schools can prohibit speech that endorse drug use, or in this case, I think it was marijuana use, in terms of the in terms of the school community, and the students said, hey, this is our free speech rights. They don't have those speech rights, and schools can actually prohibit that. They don't have to allow that type of free speech, especially when it goes back to community standards. So the whole idea here is if someone's going to incite violence, is going to promote violence or rioting or some type of illicit behavior or illegal activity such as we see here, the Supreme Court ruled that schools and communities can prohibit and regulate that. That is not something that falls under that idea of free speech. Let's shift gears now to talk about number 7, due process. We have procedural and we have substantive. Procedural is are we following the right path and procedures in order to try a person in a particular case. A great example of this is the Regalt case, in which a juvenile basically said, shouldn't I have the same due process rights as adults? And the Supreme Court agreed. You do have the rights under the 4th, 5th, 6th, 7th, 8th Amendments in terms of the search and seizure, in terms of the right to be free from self-incrimination. I plead the 5th. I have the right to remain silent. Jury trials, cruel and unusual punishment, all that applies to juveniles just as much as it applies to adults. That's the procedural aspect. And then we get to substantive due process, which is a little more difficult because it's looking at this idea of fairness under due process. And we have equal protection that is here under the 14th Amendment with due process. But the idea here is, what can governments do, and is it really fair in terms of how they're measuring that out? Are they treating cases fairly in terms of similar cases with similar citizens and different results, or different ways that they're handling those cases? That would be a violation of substantive due process, and that's really where the court looks at it in terms of that idea of fairness. Let's go back to the 4th Amendment for a second. Look at search and seizure again. The exclusionary rule really came about from this Map v. Ohio case, basically going in looking for marijuana and basically finding obscene pictures and arresting them for it. It was not included in the warrant. They had no warrant in terms of searching the house, and basically the Supreme Court ruled if it's obtained illegally, you can't use it. Now there are some exceptions to that. If the police say that there really was some semblance of trying to obtain information, and they really didn't realize that they were stumbling on it and so forth. Depending on the situation, the courts have looked at that and said, hey, these are special circumstances. They were making a discretionary authority type of decision on the fly. That's really kind of different here. But in this case, if they're illegally obtaining evidence in order to use in the case, they can't use it in a court case based like what we see here, and the Supreme Court upheld that ruling. And basically what I'm referring to here is, if you look at the good faith exception, if the illegal warrant was obtained in good faith, they didn't know it was illegal, there's technical issues, the warrant, no warrant was necessary in the case, but the officer should have known better, but didn't. This is the good faith exception. And again, roll the dice in terms of whether or not they agree to this good faith exception, but that really is where this stems from. So this does apply to a number of things, and if you look on the right hand side here, you'll see the expectation of privacy. Do you have the reasonable expectation of privacy if you're in a phone booth? Well, yes, but where do we have phone booths anymore? So now people are sitting out in places and people can hear your conversations. They can even tap into your phones. There's lots of other things happening there. So the phone booth is kind of a moot point now. School locker, do you have privacy there? No. And we'll look at another case, New Jersey VTLO, where they can search items on school grounds. Your house, yes. Your house, still your castle, and they do have to have a warrant. There is an expectation of privacy there. Your trash, however, is not. You set it out to the curb or set it outside the house, it's fair game. Your car, it depends. It depends on where your car is when they want to look at it. Depends on what they may be able to see or visibly see from it. What maybe you have just thrown in the trunk, that type of thing. If you've been arrested, forget it. All bets are off. No privacy there. Everything's on the table, and anything in plain view is not an expectation expectation of privacy either. So as well as anything under your immediate control. So like I said, if you're arrested, all bets are off. They may search anything. They're going to search your car. They're going to search your person. They'll search anything that may be around you at that time, and the potential for that is much larger. Really, it's the house. It's really, and this is what goes back to the map of the Ohio case, and we'll look at this in the Kelo case in a minute. But the idea here is that your house is private. They would need a warrant to do that, again, unless the good faith exception. But the idea there is that is pretty much the only place that privacy has been upheld by the court consistently. In the Kelo case, basically, they were using thermal imaging devices to basically go down the community, go down the street, and find out places where there was high activity of different types of radiation, heat from the heat lamps that was growing marijuana in the basement, so to speak. So they could use these devices in order to basically scan the house and find out if some of these heat lamps were actually being used, and the court basically said no can do. You can't do that. That's a violation of the Fourth Amendment. Again, the home is your castle. There is an expectation of privacy there, and without a warrant, you don't have the right to do that. So the Supreme Court did uphold that. Now, when we talk about search and seizure, another aspect to take a look at here is drug testing. When we're talking about especially school participation in sports. There is that expectation of testing, and that has been upheld in the courts. If you look here at the Board of Ed v. Earls case in 2002, the rights aren't the same in school as outside of school. Obviously, participating in extracurriculars, and here they talk extracurriculars. We usually talk sports, but this could apply to any extracurriculars. Again, depending on the school system, depending on the state, in terms of the issues here. But sobriety checks on drivers in random areas around the county or around the state, public safety or national security, all of those can apply. Let's look more closely at the school aspect, though, because I know that that's one that always comes up. And this is the New Jersey v. TLO case. So basically, they need reasonable cause in order to search your person. In this case, they had it, and TLO, who was underage at the time, so they went with the initials, basically sued, saying, do they have the right to do this? And the Supreme Court came back and said, yeah, they do. It is school grounds. You agree to abide by the rules of the school when you come onto school property, and they had reasonable cause to search you. So they were within their rights to do so. So the student lost out on that case. But it is an important point in terms of what are the expectations in terms of conducting a search at school. There has to be a reasonable cause, as I mentioned. The cause standard does need to be documented, but it is low. Lockers are a part of the expectation that they can be searched, and they don't need reasonable cause in order to do so. Reasonable cause is usually for things that are on you, such as a bag, a book bag, a backpack, a purse, a gym bag, or a workout bag, or whatever. Those we're talking about in terms of reasonable cause, but a locker is not. A locker is school property, as would be a locker in a locker room or other places where you would store things. Notice that in Maryland, the security or administrators, usually 2 adults, need to be present in order to have a witness of the search. And the administrator or security officers, or a combination of the two, but this is never done by teachers. This is always done by administrators or security in terms of that, in order to document the reasonable cause that's being the search that's being conducted. Fifth Amendment basically says the right to remain silent. This came from the Miranda v. Arizona case in 1966. You'll notice the Miranda card you see down below. We didn't have that before the Miranda case. Miranda basically said, hey, I didn't know I had the right to remain silent. So if I was talking and self-incriminating myself, somebody should have explained that to me. And so this is where you have the right to remain silent came from. The whole idea of anything you say can and will be used against you in a court of law. You have the right to talk to an attorney if you can't afford one. One will be appointed to you at the cost of the court. And this is where this language was then invoked in terms of that. So the Supreme Court did agree that a constitutional right to an attorney and the right to remain silent and be free from self-incrimination was a right that was afforded under the Fifth Amendment, again incorporating that right case by case, amendment by amendment. Fast forwarding to the Sixth Amendment, then we have the right to counsel. This is the Gideon case I mentioned in class, 1963. Basically, a police officer approaches him in a bar, accuses him of a crime of another bar down the street that's been broken into. He's sitting there with a pocket full of nickels, and they say, hey, they broke into the vending machine and stole all the change. Doesn't look very good for poor Clarence Earl Gideon. And he is arrested. There is a trial. He can't afford a lawyer, and he wants the court to appoint him one. They said no, only in capital criminal cases that involve, some type of either homicide or some type of attempted murder or murder charges. Otherwise, we don't have to give you one. And he appealed that case. He actually lost that case initially because he didn't have a lawyer. And so he appealed it to the Supreme Court. And they agreed. They agreed with Gideon. They actually granted cert. They granted writ of certiorari, agreed to hear the case, and basically sent the case back to the court with Gideon having an attorney, and they actually overturned the case. The lower court actually did rule that with Gideon having an attorney, he was able to declare his innocence, and they did find out ultimately who did it, and it wasn't Gideon. So that is an important point to note, that now we have a right to counsel, a right to an attorney if we can't afford one under the Sixth Amendment because of Clarence Earl Gideon. And that, again, is selective incorporation, applying the Sixth Amendment now via the Gideon case to the states, selectively amendment by amendment, case by case. The last one we're going to look at is the Eighth Amendment, and this is cruel and unusual punishment. The case of Greg v. Georgia, the 1976 case, basically said, hey, is the death penalty really something that we can do if we're banning cruel and unusual punishment under the Eighth Amendment? And the Supreme Court said yes. They upheld the use of the death penalty, saying that it wasn't cruel and unusual punishment. Now, again, that it does depend on the type of death penalty punishment we are talking about. The earlier versions of the death penalty, hanging, for instance, have a long, or the gas chamber, I think in most states has been outlawed. I can't think of one off the top of my head, but I could be wrong. But here you can see the latest map, and this is from the Death Penalty Institute, that basically looks at the states that still have the death penalty, those that don't, and those in which there's a governor-imposed moratorium. Now, back in 2012, we passed a referendum in Maryland that basically outlawed the death penalty. So you'll see that Maryland there is in blue. Virginia is not, as is most of the Deep South and some of the West. The death penalty still applies. But it is Greg v. Georgia that basically applied that to the states in terms of states being able to use it according to SCOTUS, the Supreme Court of the United States. I hope you found this helpful. These are the top 12 highlights from Chapter 15. Stick around because we'll be back with Chapter 16 and looking at civil rights in the next chapter. Good luck on the quiz, test, exam, AP exam. Live the 5. See you soon.